Who knew that Megan Thee Stallion was also getting sued? I know we covered the lawsuit where she was suing for defamation, but there's a whole nother lawsuit out there that looks like it's from last year of one of her employees suing her for harassment, saying that she is doing that on the basis of his gender and his sexual orientation. So y'all let me know if y'all have heard about this case. And if you have heard about this case, when did you hear about it? Because I literally just heard about it after Nicki Minaj tweeted some shady stuff talking about what you can and cannot do in front of your employees. Like, yes, it is okay for people to be sexually liberated, but you cannot force people to be involved in that stuff. So today we are going to be going over the judge's opinion on why they do not think that this case can be dismissed at this point. So at this point, there has been two complaints filed, the first complaint and then the first amended complaint. And then we got a couple of motions to dismiss filed by Megan Thee Stallion and other production companies, her production company, Rock Nation, all kinds of places. I think it's like a couple of defendants that were sued, like at least 10 defendants that were sued in this case. And so they're trying to get this thing dismissed. Like, it basically has no claim. Now, I have to let y'all know I did not read the actual complaint or the amended complaint, so we may be missing some of the facts that may be important to this, but the judge does point out the facts that they think is important in this actual lawsuit. So that's what we're going to start off with. And then we're going to go into talking about the different claims of whether the judge thinks that they should go forward or whether they should not go forward. If you guys are watching on the live stream, make sure you are dropping in the chat section your thoughts on the case as we go forward, any comments, any concerns, any questions, and we'll get to the chat after we get a little bit through the document. So without further ado, how do you say that? Further ado? I don't know. But let's go ahead and jump into the introduction. Where is Bossy B? All right, so let's have our little thingy mabob come onto the stage. Where do we want to be? No, I don't want it that small. Where we go? This one. Here we are. So we are in the United States District Court of the Southern District of New York. It was originally filed in California Superior Court, and then it got removed out of that court into the New York District Courts, and that is good for us because we can get the documents for free. Well, not always for free, but most of the time for free. Okay. So let's go ahead and see what facts the judge actually thought was important in deciding whether this motion to dismiss should be granted. So Emilio Garcia worked as a cameraman in rapper Megan Thee Stallion's entourage. Mr. Garcia traveled with the entourage all over the world and worked long hours. He alleges that as part of his duties, he was required to attend strip clubs. He also alleges certain lewd and abusive behavior directed at him from Megan Thee Stallion herself. Mr. Garcia asserts 19 claims against Megan Thee Stallion and the corporate entities that he alleges employed him. The claims include wage and hour violations, hostile work environment, and retaliation under the California and New York laws. Now, as you can see, he's claiming that 19 claims against her, but this motion to dismiss is only against, I think, 3 claims, but under different state laws. So there's going to be a couple of things we're going to be going over in this. So when we're talking about the motion being dismissed or moving for the motion to be dismissed, the whole thing is not in question here because there's 19 claims. Only these few claims that we're talking about are what's in question for what we're talking about today. So let's keep going here. Defendants move to dismiss plaintiff's claim for failure to allege facts sufficient to state a claim under the laws of California and New York. The court holds that plaintiff fails to allege facts sufficient to plausibly plead a California hostile environment claim, overtime and notice claims under California labor law, overtime claims under New York labor law, and aiding and abetting claims against the corporate entities under New York law, New York human rights law. Plaintiff adequately pleads a meal and rest break claim under California law, retaliation under California and New York law, and discrimination under New York human rights law. Therefore, defendant's motion to dismiss is granted in part and denied in part. And I know that Megan Thee Stallion would really just prefer if this all went away. Like, we were literally just on her side when the defamation lawsuit was going forward, and we talked about that. And now we find out that she is also being a problem to her employees. And as we go through this, if you guys have been rocking with us for a while, as we go through this, you're going to see some things that are similar to the Lizzo claim that the employees against Lizzo made against her, which we know is up on appeal right now. So there's not much really happening in that lawsuit. And this one, with the fact that the court was not willing to dismiss some of the important claims that this guy is making against Megan Thee Stallion, we could probably see a settlement coming forward, or we might see a little bit of a pause until she sees what happens with Lizzo's lawsuit, because these are entertainers and they're being accused of pretty much the same thing. Okay, so let's keep going here. All right, so let's start with the parties. The plaintiff is a resident of Texas. Then we got the defendant, Rock Nation, which is a Delaware limited liability company. We got defendant Hot Girl Touring, which we know is Megan Thee Stallion's business, a member of, or a business from Florida. Defendant Megan Thee Stallion Entertainment. Again, that's another corporate defendant of Delaware. And then we got Megan Pete, who is actually the person as Megan Thee Stallion. Okay. Plaintiff is hired by the defendants and joins Pete's entourage. In 2019, plaintiff was hired to serve as Pete's personal cameraman. This was a full-time position. Plaintiff was classified as an independent contractor during his time working for defendants. We see this happening a lot with small businesses or like celebrities just saying, okay, well, you're an independent contractor, because at that point, I don't have to do all the real employment law things, when 9 times out of 10, even though you're calling them a contractor, you're in control of their work. So they are going to be considered an employee later on down the line, which is basically what he's suing for. Even though you told me that I'm an independent contractor, I was actually your employee and you owed me certain things that you didn't do. So this is what happens when we have young people becoming famous and starting businesses and they don't really know what they're doing, right? So the Rock Nation definitely should have known what they were doing. So anyways, plaintiff was classified as an independent contractor during his working time for defendant, but plaintiff alleges that he did not provide personal cameraman services independently of his relationship with Pete. That's going to be important later on. Pete specifically told plaintiff he was not allowed to service any other client other than himself. Initially, plaintiff was paid a monthly flat rate of $4,000. Because he was classified as an independent contractor, he did not receive health insurance, right? Because she's saying, you're not an employee of mine. And honestly, Megan Thee Stallion, with being an entertainer, she probably has to pay for her own health insurance as well. Okay. Plaintiff had to travel with Pete and her entourage as part of his duties. Plaintiff did work for defendant primarily in California and New York. On average, plaintiff was in New York at least once per month and sometimes remained in New York for weeks at a time. While traveling with Pete, plaintiff was required to stay at the hotel and to be on standby at all times. Plaintiff essentially worked during all waking hours of the day and worked in excess of 50 hours per week, but plaintiff was denied overtime pay at an overtime rate. Defendant also maintained inaccurate work records, which did not properly record plaintiff's working hours. And I do want to stop and make clear that this is a review of a motion to be dismissed. So the facts that the court is relying on are the facts in the complaint, because that's pretty much the only document that's really given any facts and being pled under penalty of perjury. So it sounds like it's definitely in favor of the plaintiff, but it kind of has to be that way because they're taking the facts from his actual complaint. So let's not think that the court is completely on this guy's side, okay? They're just wondering if this complaint actually states a claim, right? Okay, so Pete controlled, and when we're talking about Pete, we're talking about Megan Thee Stallion. Pete controlled and directed the work performed by plaintiff. More than once, Pete would interrupt plaintiff during dinner and demand that he immediately shift his focus to assist her with TikTok creative ideas. Pete continuously contacted plaintiff at all hours, directing him to brainstorm TikTok videos, to edit content with that plaintiff had not captured, and to complete various assignments. Plaintiff was denied a meal break or a rest break and was never paid meal or rest break premiums during his entire employment, which would be required if the court is finding him to be an employee of Megan Thee Stallion. Plaintiff was required to not only take photos, videos, and edit content, which was all done under the strict control and direct supervision of Megan, but also to accompany Megan almost anywhere she went as part of the entourage. The entourage included Pete, plaintiff, Pete, plaintiff, dancers, makeup artists, nail techs, and others. Pete was perceived as the leader, and all others were the subservients. Members of the entourage were unable to spend their time for their own benefit and were present only to attend to the needs and demands of Pete. Well, it's like a work trip, but technically during work trips, you are supposed to have breaks where you're not actually working. So I think it gets a little bit muddy when we're talking about the entertainment industry because, of course, the person that you're working for is going to be one who you want to be around because they're going to be doing all the fun stuff. And two, you're then there on business. So it's kind of hard to distinguish. And I think that's the same thing that came up with the Lizzo lawsuit. It's like, yeah, you work for me, but also don't you want to go out and have fun because I'm your only friend on the trip, right? Or is it really that you wanted to explore on by yourself? Were you really not into going to these clubs and things of that nature? So let's keep going here. Okay. As a result, plaintiff was afraid that Pete would retaliate against him if he refused to acquiesce to her every demand. Pete puts plaintiff in uncomfortable situations. As part of Pete's entourage, the plaintiff was required to attend strip clubs, nightclubs, and other excursions. Again, did you really want to be locked up in the hotel room or traveling across the country by yourself? I don't know, but that's up to him to prove it, right? Megan compelled plaintiff to go on dozens of trips to strip clubs in New York, California, Atlanta, Georgia, and overseas. Plaintiff attended strictly out of his duties to his employer, not for his pleasure or benefit. And I guess he can make that argument because he was the cameraman, so he would have to record things. But again, what's his plan to just hang out by himself? I don't know. On one occasion, on or around February 15, 2022, plaintiff and the entourage were required to accompany Megan to a New York City strip club. Plaintiff went to the strip club only because Megan required him to. At one point in the evening, Megan began physically touching the dancer in a sexually provocative manner, which made plaintiff feel extremely uncomfortable, embarrassed, and disgusted. Plaintiff tried to avoid the situation, but was unable to leave. Later in the evening, plaintiff made a joke about being related to one of the dancers who shared his last name, and Pete shot a sinister look at him. So basically insinuating like, oh, can you dance like that is what I'm picking up on from that statement. Eventually, plaintiff removed himself from the situation and proceeded to leave the strip club and wait in one of the SUVs in the convoy, waiting for Megan and the entourage. In or about June 2022, plaintiff traveled with Megan to Ibiza, Spain. One night during this trip, plaintiff was required to join Megan and the entourage at a nightclub in Ibiza. After leaving the nightclub, plaintiff and Megan, along with three of Megan's female best friends, got into an SUV. Plaintiff was only present in the SUV to perform his duty as Pete's employee. Again, he's making it clear that this was not what he wanted to be doing while he was in Ibiza, okay? He was not trying to hang out with Megan Thee Stallion, which I find hard to believe, but it's going to be up to him to prove that part of the case. So Okay, so the SUV had two bench seats that allowed the passengers to face each other. Pete, who was allegedly intoxicated, proceeded to engage in sexual conduct with her friends in the SUV. Plaintiff was unable to remove himself from the situation. The sexual conduct taking place in front of plaintiff made him feel extremely uncomfortable. So she's basically engaging in adult activities with another girl in front of him, and he's saying that made him uncomfortable, and that was discrimination / harassment of him. Because Megan basically would not have done that if he was a heterosexual male, but instead he's homosexual. So she felt comfortable doing it in front of him. So it's a leap that he wants us to make, but I think that's going to be a hard one to convince people of, because we don't know if she would have done that in front of a straight guy, right? I don't know. So let's keep going. Later the same evening, plaintiff, Megan, her friends, and other members of the entourage were having dinner at the residence where they were staying. Suddenly, plaintiff felt Well, suddenly, plaintiff felt Megan was giving him a dirty look once again. Pete shouted at plaintiff so everyone could hear, "Are you really eating that, you fat?" Uh-oh. Let me get my sensors together. You fat? Oh, don't laugh. She said, she basically cussing him out. Split that out. Continue. Why are you still chewing? Spit that out. Pete then grabbed the food off another employee's plate who was sitting closer to Pete than plaintiff was and threw the food over her shoulder. Humiliated and ashamed, plaintiff excused himself and proceeded to go to sleep for the night. Plaintiff had informed Megan that he has an eating disorder and struggles with his weight. They bring this up, but then never really bring this up again throughout the explanation of why they're not denying everything. But I just thought I would point that out. The next morning, plaintiff made it clear that he did not appreciate and opposed Megan's unlawful conduct in the SUV. Megan responded, "Don't you ever speak about what happened in the car." So he basically brought up like, hey, what you did was inappropriate by engaging in the sexual conduct in front of me and other people. And it's quite frankly illegal. Like, what did we just talk about with all the stuff that's going on with Diddy? Like, you cannot subject people to sexual things when they don't want to be subjected to those things. So let's see. The condition of plaintiff's employment changed. So prior to the Ibiza trip, defendants booked plaintiff regularly, frequently, every week, and sometimes for 7 days a week. After the Ibiza trip, however, so after he brought up his complaint, defendants began to request fewer services from plaintiff, relying instead on other photographers. This change has had a direct impact on plaintiff's compensation. The financial consequences notwithstanding, Megan forbade plaintiff from working for any other celebrities or from working elsewhere. So he couldn't even get like a backup job or a part-time job or anything like that, according to him, right? In August 2022, plaintiff was with Pete or Megan and the entourage in the hotel in Portugal. While others were partying, plaintiff sat down and placed his head on a pillow. Suddenly, a TV remote was thrown at him, hitting plaintiff in the head. Pete was standing in the direction from which the remote came and shouted, what if I did throw it? Then what?" Which I feel like we're missing a lot of the conversation. Like, why would she just say, "So what if I did throw it? Then what?" Like, did he say something to her too? I don't know. What are you going to do about it? Around August 2022, defendants also altered plaintiff's compensation structure from a monthly rate to a pay per task system for each assignment. Remember, he was being paid $4,000 a month, which in my opinion sounds kind of low to be having to travel everywhere with someone. I mean, I guess unless she's covering the travel expenses and everything, but still $4,000 a month to be a celebrity's personal cameraman sounds like a low amount to me, but I could just be thinking that celebrities are richer than they actually are. I don't know. Plaintiff was informed of this change by Desiree Perez, the CEO of Roc Nation. Plaintiff was still expected to provide the same level of service to Megan. Despite being expected to work for the same amount of time as before, the new invoicing system resulted in plaintiff earning significantly less because the invoiced amounts did not accurately reflect the true time and effort dedicated to working for her. Plaintiff's assignment continued to taper off into 2023, but he was still forbidden by Pete from working for anyone else. Plaintiff was excluded from this Europe trip. Plaintiff was excluded from this Europe trip, was not compensated, yet was prohibited from working elsewhere. Defendants terminate plaintiff and interfere with plaintiff's future job prospects. In 2003, plaintiff confided in one of Megan's former makeup artists, Alex, about the unlawful pay practices associated with his work for Megan. Then in June 2023, plaintiff received a call from Alex's phone. Megan was on the other side with an angry look, I'm assuming on FaceTime, right? Megan lashed out saying, oh, I forgot about the change in voice thing. Sorry, y'all. Saying, "You want me to quit on me?" Yeah, she's cussing him out again. "You want to quit on me?" Plaintiff explained that he did not want to quit, but that he wanted to work in a respectful environment and be paid all of the wages he was owed. Pete continued to yell at plaintiff and call him a telling plaintiff that his boyfriend made him lazy. So basically, since he got in a relationship, he hasn't been doing the work as good as he used to, essentially. Megan blamed the corporate defendants and said that it was Rock Nation who books her people, not Megan Thee Stallion. So essentially, cameraman, plaintiff in this case, was like, hey, you're not even booking me as often as you used to book me, and I want you to be respectful to me when you book me. And Megan's like, well, it's not me that's not booking you. It's actually Rock Nation. They're in charge of getting me all the people that are supposed to, hang out with me, do my work for me, who they are going to pay on my behalf. They're the ones doing that. And in my opinion, I just don't think that the plaintiff should be upset about it, because as we know, with him being the cameraman and the entourage and all of that stuff, he is going to have to go with her to the nightclubs and the strip clubs and whatever else she wants to do. And he clearly doesn't like it. Now, him saying that she stopped him from having other jobs, they're just kind of vague allegations, but it is just a complaint. So he only has to state a claim sufficient enough to plead a case, right? So maybe he has more information that's going to come out in discovery, like depositions and during trial and all of the things. So, okay. Shortly after the June 2023 phone call, a representative from defendants contacted plaintiff to inform him his services were no longer required under purported change in creative direction. So they fired him. In August 2023, plaintiff was hired for a 3-day photo shoot in Los Angeles, California. But the day before the shoot, the production company moved plaintiff from the project without explanation. Plaintiff subsequently learned that the shoot was for the music video of a song featuring Megan. Upon information, oh dang, he had got another gig and Megan kicked him off. Okay. Upon information and belief, Megan interfered with plaintiff's contract and blackballed plaintiff among celebrities and performers, making it impossible for him to work in the entertainment industry ever again. Plaintiff has been unable to secure comparable employment like he had with the defendant. And then it goes through the procedural history, how it was filed in California, it got removed, blah, 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 blah. We're not going over that. We are looking at a failure to state the claim. So he basically, like we just talked about, has to plead facts sufficient enough to state a claim for the things that he is claiming. Okay. So let's go ahead. Let's go ahead and jump into the actual discussion and the arguments and what they're trying to say. So the first thing that Megan Thee Stallion objected to was saying that this was an impermissible group pleading, basically saying that, everyone did these things to me, and they're not really specifying which defendant is responsible for which claim or cause of action. And the court goes on to explain that, well, he's saying that you guys worked kind of like Megan and then Rock Nation and then the other production companies or whatever. You were all his employers. So no, this is not an impermissible group pleading. So that thing goes away. We're not dismissing it on that basis. And then we jump into whether or not the plaintiff, Emilio Garcia, was considered an actual employee of Megan Thee Stallion, of Rock Nation, of Hot Girl Touring, of all of the companies that he sued along with Megan Thee Stallion. And so we talked about it briefly earlier. When we're talking about independent contractors, you have to be completely free of the employer's control. And the reason why he's going after this is because he has a little bit more protections as an employee than he would have had as an independent contractor. And what happens with a lot of small businesses and people that just are not well-versed in business, which Rock Nation again should be, but we're not talking about that. They end up calling people independent contractors who are actually employees. And we see that again with the Lizzo lawsuit and now with this lawsuit with Megan Thee Stallion. So again, y'all, we are live. So if you are watching the live stream, make sure you're dropping in the chat your thoughts. If you're watching on the replay, make sure you're dropping in the comments your thoughts. And if you haven't already, please do hit the like button. Oh, and I also did notice that YouTube now has like a leaderboard. So like people that are commenting in the live stream, you get like little badges next to your name for being active in the live stream. So that's cool too, if you want to see a little crown next to your name, okay, and be on the leaderboard. I don't know how to work it yet, but it looks like it's already going. Yeah, so we got top fans already up with Kimmy. We got Mary. We got Lola Waterton. We got Layla Wells. We got JD Boy 2000. So 5 people are on the leaderboard already. Are y'all able to see the leaderboard on YouTube? I just got the email like yesterday, I think. So just let me know if y'all can see it or not. But I can see it on my end. Okay. Anyways, let's get back into it. So was the plaintiff an actual employee of Megan Thee Stallion? So plaintiff alleges facts sufficient to plausibly plead that under both New York law and the California Labor Code, he was in fact an employee, a defendant, not an independent contractor. Under the New York law, plaintiff plausibly pleads that he was an employee of all the defendants under the law. Under the law, the critical inquiry is determining whether an employer relationship exists or an employment relationship exists pertains to the degree of control exercised by the purported employee or employer over the results produced or the means used to achieve results. Factors relevant to assessing control include whether the worker worked at his own convenience, was free to engage in other employment, received fringe benefits, was on the employer's payroll, and was on a fixed schedule. So the fringe benefits are basically like the extra stuff, like the health insurance, retirement, all the things that people say, oh, these are the benefits that come with the job and working for us. So plaintiff alleges that he did not work at his own convenience, rather as part of Miss Pete's entourage. Plaintiff was unable to spend his time to his own benefit. Plaintiff was forbidden from leaving the entourage. Throughout his employment, his constant availability was required. Additionally, plaintiff had to travel with Megan and her entourage, and when doing so, he was required to stay at a hotel and be on standby at all times. Plaintiff alleges that he was not free to engage in other employment. Ms. Pete forbade plaintiff from working with anyone else, even as his work assignments tapered off. Plaintiff plausibly alleges that he was on defendant's payroll, initially making monthly salary of $4,000 per month, and before his compensation structure was changed. Plaintiff also alleges that he was on a fixed schedule, working full time for plaintiff at all hours of the day. Finally, I don't know if that constitutes as a fixed schedule, but okay, that's what the court went with, okay? Finally, plaintiff alleges that defendants exerted significant control and supervision over the process and results of his work. Therefore, plaintiff alleges facts sufficient to plausibly plead that he was an employee of the defendants under the New York law. So yeah, the fixed schedule to me, but again, I'm not a labor and employment attorney, but fixed schedule is like Monday to Friday, 8 to 5:30 or whatever the schedule might be, but not just, oh, you are just available at my fully beck and call. I mean, I guess there could be an argument that he was like a salaried employee because he was just paid a flat rate of $4,000 per month. I was just moving my arm. I'm like, why does my arm hurt? Why does my arm hurt? I went to Top Golf yesterday and thought I was freaking Tiger Woods. I don't know. Is it swollen? My arm is so sore. I like try to straighten it. It straightens, but it hurts. Okay, let's keep going. Let's stay on topic, Bree. Stay on topic, okay? So about the plaintiff as far as Rock Nation, again, they are also trying to get this case dismissed. Like, did he work for Megan Thee Stallion? Yes, but also did he work for Rock Nation? And they're going to say the question is whether they exert ultimate control over the worker. That does not preclude a finding from another entity exerts sufficient control to qualify as a joint employer. Because the statutory standard for employer status under the law is nearly identical to the FLSA, courts in the district regularly apply the same test to determine whether they were joint employers. So just because Megan was the employer does not mean that he couldn't have another employer. The joint employer test is a flexible concept that should be analyzed on a case-by-case basis. After reviewing the totality of the circumstances, an entity can be considered a joint employer if it exercises either formal control or functional control over the worker. As we talked about earlier, remember, they fired him. So let's keep going. The formal control test asks whether the alleged employer has the power to hire and fire employees, supervise and control employees, work schedules or conditions of employment, determine the rate and method of payment, and maintain employment records. Based on what we read earlier, it sounds like Rock Nation is going to qualify as a joint employer. No one of these factors is dispositive, nor are they as a whole exclusive. The Second Circuit has held that determining joint employer status is a question of fact, not suitable for resolution on a motion to be dismissed. Remember, the judge has to determine whether we have facts that are sufficient to state a claim, but ultimately is going to be the fact finder, like the jury's responsibility to determine whether, in fact, Roc Nation was or was not a joint employer. So plaintiff has plausibly pled that Roc Nation's formal control over employment is sufficient to survive a motion to dismiss on the basis of joint employer status. Plaintiff alleges that Roc Nation had the power to terminate his employment and to determine the rate and structure of his compensation. Specifically, plaintiff alleges that CEO of Roc Nation personally contacted him to alter his compensation structure from monthly rate to a per task system. The plaintiff alleges that it was Roc Nation that reached out to him and informed him that his services were no longer required. While Roc Nation argues in its briefing that it did not have any rights to terminate the engagement and merely communicated Megan's decision to the plaintiff on her behalf, that assertion is belied by the allegations of the amended complaint, which the court must accept as true at this stage of the litigation. So just because you were doing Megan a favor, you still came off, it's based on the complaints, not the arguments that you're making in the motion to dismiss. So based on the complaint, you fired him, right? It wasn't Megan said she no longer wants you to work for him. Then you got Megan saying, well, Roc Nation is the one not booking you. So basically they're each pointing the finger at each other. So that's not really a good argument, Roc Nation, okay? Likewise, Roc Nation's assertion that it merely communicated Ms. Pete's decision regarding compensation is belied by plaintiff's allegation that when he confronted Ms. Pete about the wages, she said Roc Nation books her people. Exactly. A motion to dismiss is not the proper vehicle to resolve these factual disputes. At this stage, plaintiff has alleged enough facts to suggest that Roc Nation had a formal control over his employment and therefore that Roc Nation was a joint employer. I definitely agree with the court on that issue, okay? Plaintiff plausibly pleads that Roc Nation is a joint employer for the purposes of this other law. They basically say, as we said above, see above, okay? And then under California law, it's not clear, although in the beginning of this paragraph, it said that he pled facts sufficient, but now they're saying it's not clear under California law. But anyways, let's keep going. It is not clear from the face of the amended complaint that plaintiff was an independent contractor under California law. Under California law, a worker is properly considered an independent contractor only if the hiring entity establishes that the worker is free from control and direction of the hirer in connection with the performance of the work, both under the contract for the performance of such work and in fact, B, the worker performs work that is outside of the usual course of the hiring entity business. C, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed as by the hiring entity. The burden is on the hiring entity to establish that the worker is an independent contractor by establishing each of the three factors. Therefore, at the motion to dismiss stage, plaintiff's status as an independent contractor must be clear on the face of the complaint. It is not clear from the face of the complaint that plaintiff is an independent contractor under the ABC test. As discussed above, plaintiff alleges that the defendant exercised control and direction over his work. Plaintiff also alleges that he does not provide personal cameraman services independently of his relationship with Megan Thee Stallion. Let's see. Therefore, it's not clear. Wait, let's see what the cited case says. The cited case says when a worker has not independently decided to engage in an independently established business, but instead is simply designated as an independent contractor by the unilateral action of the hiring entity, there is substantial risk of misclassification. I think that the court just kind of skipped to a conclusion here and didn't really finish off their thought. Because then the next sentence is just, therefore, it's not clear from the face of the complaint that prongs A and C are met in this case. Indeed, the allegations suggest otherwise. Huh? Oh, they're basically arguing. Okay, I get it. It's on the defendant to prove these elements. So they're basically saying that Megan Thee Stallion, based on what the complaint says, that the plaintiff is already contradicting the arguments that Megan Thee Stallion and the other defendants will have to make in order to say that he is an independent contractor. I think That is what the kind of explanation that they're going for. Okay. That confused me. So, however, the California Labor Code does not create a private right of action. Plaintiff's 13th claim against plaintiff for misclassification under the section must be dismissed because I don't know why. They didn't really give me a lot of information on that, and it kind of confused me. So we're going to move on to the next thing. So let's talk about the hostile work environment. So we talked about whether he's an independent contractor. Now, at the beginning of that paragraph, it said that he pled that he was an independent, or he was an employee under both laws. And then we got to the end and said, well, it's not really clear about California law if he was an employee, but under New York law, he would have been considered an employee for the purposes of the claims that he's making. So a little confusing, but done nonetheless. Okay. So now let's move on to the hostile work environment and the discrimination claims that Emilio Garcia is making against Megan Thee Stallion. Okay. Megan Thee Stallion. So let's see. Plaintiff has failed to adequately, God dang, you just telling us the answer from the beginning? All right. Plaintiff has failed to adequately plead that defendants created a hostile work environment under the FEHA, Fair Employment Housing Act, I think it is. California courts have adopted Title VII standard for hostile work environment sexual harassment claims under FEHA. Therefore, under FEHA, a hostile work environment sexual harassment claim requires a plaintiff employee to show that she was subjected to sexual advances, conduct, or comments that were unwelcome because of sex and sufficiently severe or pervasive to alter the condition of her employment and create an abusive work environment. To plead a cause of action for hostile work environment sexual harassment is only necessary to show that gender or sexual orientation is a substantial factor in the discrimination, and that if the plaintiff had been of an opposite gender or sexual orientation, she would not have been treated in the same manner. Let's see. Accordingly, that was still a case. The objective severity of harassment should be judged from a perspective of a reasonable person in the plaintiff's position, considering all circumstances. The inquiry requires careful consideration of the social context in which particular behavior occurs and is experienced by its targets. The real social impact of the workplace behavior often depends on a constellation of surrounding circumstances, expectations, and relationships, which are not fully captured by a single recitation of the words used or physical acts performed. Plaintiff concedes that FEHA does not protect non-residents when the torches, where the tortious conduct take place outside of California. So, Therefore, for the purposes of plaintiff's FEHA claim, the court considers only 3 allegations that plaintiff asserts are related to California. The plaintiff was required to accompany defendant Megan to multiple strip clubs in California. The plaintiff suffered harm in the state, and that a plaintiff lost work opportunities in Los Angeles due to the interference. First, plaintiff failed to adequately plead that the excursions to the strip club in California constituted harassment on the basis of sexual orientation. He alleges that the entire entourage, which we've already talked about, had women and men in it, were brought to those events. He does not allege that he, as a gay man, was singled out for participation in any way. What happened to me? Am I gone? Okay, that was strange. Did you guys see that? Oh gosh, I think I think I'm frozen. Come back to life, Bree. Okay, I think it's coming back. It's coming back. My Wi-Fi is not doing too hot right now. Okay, it's not doing too hot. Okay. Mary Jane says that she can still see me. So let me just turn off my Wi-Fi on one device. I think there's just too many devices on the Wi-Fi. Okay. So keep going. He does not allege that he, as a gay man, was singled out for participation in any way, or that Miss Pete was targeting him by planning these events. Let's see here. Desperate treatment on account of his sexual orientation. Plaintiff merely alleges that as a gay man, he is not attracted to women. That is not enough for harassment. You can go to the strip club and not be attracted to the people there. Yeah, because you don't have to be attracted to them. Okay, anyways, and therefore he attended strip clubs strictly out of his duties for his employer. Plaintiff fails to state a claim of hostile work environment under FEHA merely by alleging that he was forced to attend clubs against his wishes, with no allegation that the requirement was because of his sexual orientation. A hostile work environment sexual harassment claim is not established where a supervisor or coworker simply uses crude or inappropriate language in front of employees or draws a vulgar picture without directing sexual innuendos or gender-related language towards a plaintiff or towards the protected class in general. Second, plaintiff's vague and conclusory argument that he suffered unspecific harm in California is not sufficient to allege severe and pervasive harassment under FEHA. Third, the plaintiff's allegation that he lost work opportunities in California when he was no longer employed by defendants at the time of the alleged occurrence. Let's see. In any event, his one allegation that he was removed from a photo shoot is not enough to demonstrate severe, pervasive, hostile conduct, basically saying that a single incident is not enough to prove harassment. Plaintiff's allegations therefore fail to state a hostile work environment claim under FEHA. Because plaintiff fails to state a FEHA claim against Megan, plaintiff's 12th claim against corporate defendants for failure to prevent a remedy of harassment under FEHA also fails. Let's see. And that was it. That was the end of that paragraph, other than citing cases. I think that this court just kind of skips over a lot of things, in my opinion. But anyways, did he plausibly plead discrimination under the New York laws? Let's see. They think he did. So I guess New York laws are a lot less strict than the California ones. So let's see. Plaintiff plausibly pled that he faced a hostile work environment on account of his sexual orientation sufficient for his New York claims to survive at this stage. The law in New York prohibits an employer from discharging or discriminating against an individual in compensation or in terms, conditions, or privileges of employment because of the individual's sexual orientation, sex, or disability. To establish a hostile work environment under the New York law, the plaintiff must only demonstrate by a preponderance of the evidence, so really 51-49% difference, right? You just got to be 51% right, that she has been treated less well than other employees because of her gender, disability, or sexual orientation. The plaintiff bears the burden of showing that the conduct is caused by a discriminatory motive. It is not enough that a plaintiff has an overbearing or obnoxious boss. She must show that she has been treated less well, at least in part because of her protected characteristic. Now, I don't know if it's just me, or is like the language of the statute a little bit sexist? Because it just keeps saying she, and this is clearly a guy. So why are we calling him she? But it's just the way the law is written. So the law is kind of sexist in itself, but they're applying it at least to men as well. So I guess I can't really say it's just sexist. Okay. Let's keep going. Because plaintiff worked in New York, plaintiff's allegation of conduct outside of New York can form a basis for because plaintiff worked in New York, plaintiff's allegation of conduct outside of New York can form a basis for state and city human rights law claim. The New York Court of Appeals established an impact test for non-residents seeking to assert a claim under the state and city human rights law. There are two ways in which a non-resident may satisfy the impact requirement: working in New York, or establishing that he challenged conduct or establishing that the challenged conduct has some impact on the plaintiff within the respective New York geographical boundaries. The impact test expands the protection of human rights laws to non-residents who work in the state or city, and to those who state a claim that the alleged discriminatory conduct had an impact in either of those locations. They basically say because he worked in New York for Megan Thee Stallion in general, he can sue under the law, basically. But it doesn't really specify like what conduct. I think it talks about the Ibiza claim. Okay, yeah, it is. Okay. I was wrong. At this early stage in the litigation, plaintiff plausibly pleads that the alleged sexual encounter in the SUV in Ibiza created a hostile work environment based on plaintiff's sexual orientation. Defendants do not dispute plaintiff's contention that the alleged SUV incident would constitute a hostile work environment as defined under the New York law. Defendant merely disputes whether plaintiff has alleged facts from which one may infer a causal relationship between plaintiff's social orientation and his being subject to the incident. Plaintiff asked the court to draw the inference that Megan would not have engaged in group sex with other women in front of a heterosexual male. Again, we don't know if that's actually true. That Megan felt comfortable engaging in group sex with other women in front of plaintiff because of his sexuality and gender. That this is not an unreasonable inference to draw from the facts alleged. Therefore, plaintiff was plausibly pleaded that he experienced the alleged inferior conditions of his employment on account of his sexual orientation. But I don't know if I all the way agree with that, because wasn't there other girls in the car that was not participating? So I don't know if you can, I guess it's just off his sexual orientation. But what if the girl's sexual orientation was hetero? Like, I don't know. I think it's a stretch. But again, it's a question of fact that he is going to have to prove to a jury, not to me, okay? Let's talk about the overtime. He's saying he was working, and Megan Thee Stallion was not paying him, okay? Let's talk about the overtime. So the sexual conduct thing is literally only the Ibiza sex in the truck thing. It's a stretch for me, but let's keep going. Plaintiff has not adequately pled violations of California overtime wage law. They do not want him to succeed in California. So I guess it was better for him to have this pulled out of California, because the district court is basically saying, no, he doesn't qualify under California law. I think the other thing that might play a role in him not qualifying under California law is that maybe the New York court is not as familiar with the California law. And while they do have to apply the legal standards of California, maybe they just don't want to burden themselves with that. And they don't know exactly how everything applies, because they're in New York and they deal with New York law. So they know how to deal with New York state laws, but they don't want to take that stretch over to California. That's just an opinion of mine. I don't know if that's actually the case here, but it seems like they just don't want to deal with any of the California laws at this point. So let's keep going. Here. Okay. Plaintiff has not adequately pled a violation of the California Labor Code overtime provisions. The plaintiff asserting violations of the overtime provisions must allege that she worked more than 40 hours in a given work week without being compensated for the hours worked in excess of 40 during the week. A plaintiff need not allege with mathematical precision the amount of overtime compensation owed by the employer. Instead, she should be able to allege facts demonstrating there was at least one work week in which she worked in excess of 40 hours and was not paid the overtime wages. The Supreme Court of California has held that the Labor Code provision applies to non-residents for work performed in California. Courts must apply California's overtime law to full days and weeks of work performed there by non-residents. Plaintiff has failed to allege that he worked overtime for any given day or week of work in California. Plaintiff merely alleges that he spent a substantial amount of time working in California, and separately alleges that during his employment, he worked sometimes 16 plus hours a day in excess of 50 hours a week. Plaintiff does not allege any of these 16-hour days occurred in California. He just kind of makes a general statement that he was working a lot, okay? And his main work areas was California and New York. And even if the court were to interpret plaintiff's allegations to mean that he worked in excess of 50 hours every week, he does not allege that any of these weeks were full weeks in California. Plaintiff does not allege that there was at least one full week in California in which he worked overtime. So basically giving him the roadmap about what to put in his second amended complaint, okay? Like, be more specific, sir. Okay? Okay, therefore, plaintiff has failed to adequately plead the defendants violated California Labor Code's overtime provision. Plaintiff has not adequately pled violations of California's wage statement law. Because plaintiff has failed to plausibly plead that he performed a majority of his work in California or or that he is based in California for work purposes, plaintiff fails to state a claim under this labor code. The labor code requires an employer to supply each employee semi-monthly or at the time of each payment, a written wage statement listing the employer's name, address, identifying pay period, itemizing the total hours worked, applicable hourly rates, hours worked at each rate, gross and net wages earned, and any deductions taken, and disclosing other prescribed information. To determine whether the code section applies, the court should consider in first instance whether the employee works the majority of the time in California or in another state. For employees who do not work principally in one state, a court should consider secondarily whether the employee has a definite base of operation in California. In addition to performing at least some work in the state for the employer, an employee is based in California if California serves as a physical location where the worker presents himself or herself to begin work. The employer's location is not pertinent. So if your employer has you going to California to do work, but they're based in New York, you could still, be not found guilty, but liable under this law, essentially is what it's saying. And essentially he didn't argue that. He just said he worked a lot in California and in New York, but he doesn't really give how much in each place that he worked. And it's saying you worked there 31% of the time, which was one of the examples they gave, would not be enough. So he needs to give us more information about why he thinks he qualifies under this law. So let's talk about plaintiffs failed to adequately plead a violation under New York overtime law. So, okay, New York is starting to get some smoke too. He can't qualify under New York either. So let's see. Plaintiffs claim under New York law plaintiffs claim for failure to pay overtime is pleaded with insufficient detail to cross the line of plausibility. In 2013, the Second Circuit decided a trilogy of cases which set contours for pleading a case for failure for overtime wages. I'm not going to go over those cases because it's a long thing. The amended complaint suffers from the same deficiencies as in De Jesus. Plaintiff simply alleges that during the unspecified period, plaintiff worked in excess of 50 hours. And was not compensated at the statutory minimum wage and overtime rate. Plaintiff simply adds 10 hours to the very same threadbare allegation for the Second Circuit, deemed to be a rephrasing of statutory formulation. Plaintiff has failed to nudge his claim from a conceivable to plausible. While the court need not reach the issue, the court also notes that, as with plaintiff's California overtime claim, the amended complaint fails to delineate which weeks and hours of overtime plaintiff worked. Without sufficient detail about the length and frequency of her unpaid work to support a reasonable inference that she worked more than 40 hours in any given week, plaintiff fails to state a claim for overtime pay under the labor law. Okay, so he needs to give us more information, okay? Let me see. And then defendants provide no basis on which to dismiss plaintiff's claim under the New York wage and notice statement. Defendants offer no argument beyond those already addressed elsewhere in this opinion why the court should dismiss the New York claim for failure to provide accurate wage notices and wage statements. Under the law provides a private right of action for violations of the section, failure to provide wage notices and wage statements. Defendant fails to address plaintiff's claim separate from the arguments that plaintiff was not an employee. Therefore, the court declines to dismiss the claim. So they basically didn't argue right. Okay, y'all get out of here. Meal and rest break claim. We are on to the next part. So he is not winning on the wage statements. He needs to tell the court when he worked overtime. Was it the week of 4th of July? When was the week that he worked overtime? He got to give some more information. So let's talk about the meal and rest break claims, claiming that they was making him work instead of eat, okay? The court declines to dismiss plaintiff's claim that defendants violate the meal and rest break provision of the California Labor Code. The defendant's only argument for why plaintiff fails to state a claim under this code is that plaintiff does not allege the reason his meal and rest periods were denied. What a dumb argument. However, the case on which defendants rely does not require the plaintiff to allege a reason for his meals and rest breaks were denied. The case only held that it is insufficient for the plaintiff to allege that he skipped them by his own choice, which he didn't. He said he was trying to eat. And then Megan was like, let's film a TikTok. Let's not eat. Let's film TikTok. Okay. However, in this case, unlike in Bunkley, plaintiff has alleged that defendants impermissibly denied those breaks during the entirety of his employment, which one can reasonably infer includes his time in California. Therefore, defendant's motion to dismiss the 13th claim of the amended complaint is denied. Retaliation claims. We're moving right along. Did they retaliate by firing him? Let's see. Plaintiff sufficiently pleads claims for retaliation under the New York law, and the law prohibits retaliation against any person because he or she is opposed to any practices forbidden under the article and because he or she has filed a complaint, testified, or assisted in any proceeding under this article. Under the law, the law is materially identical to another code section which prohibits employers from retaliating or discriminating in any manner against any person because such person has opposed any practice forbidden under the chapter. After the 2019 amendment to the law, the standard for the claim is closer to the standard of a different law. Let's see. Accordingly, the plaintiff must plead that he engaged in a protected activity as that term is defined under the law. His employer, number two, his employer was aware that he participated in such activity. Number three, his employer engaged in conduct which was reasonably likely to deter a person from engaging in the protected activity. And number four, there is a causal relationship between the protected activity and the alleged retaliatory conduct. Similarly, under another New York law, they provide in pertinent part that no employer shall discharge, threaten, penalize, or in any other manner discriminate against the employee because such employee has made a complaint to his or her employer and that employer has engaged in conduct that the employee reasonably in good faith believes violated the law. Let's see. The elements of that is that the plaintiff must plead participation in a protected activity known to the defendant. Two, adverse employment action affecting the plaintiff. And three, a causal connection between the protected activity and adverse employment action. So pretty close. Both of them are pretty close. It basically prevents them from discriminating against the whistleblower, right? So what are these protected activities that plaintiff is alleging here? Plaintiff adequately alleges that he engaged in protected activity when he confronted Megan about her treatment of him during the Ibiza incident and about her failure to pay plaintiff the wages he was owed. The court is sympathetic to the defendant's argument that plaintiff's allegation that he opposed Megan's unlawful conduct and opposed the defendant's unlawful wage practices are rather vague and nearly threadbare recitals of the elements of the claim. But defendants are incorrect that plaintiff must allege that he specifically identified the unlawful conduct to be discrimination. Rather, the New York Court of Appeals has held that opposing any practice can include situations where a person, before the retaliatory conduct occurred, merely made it clear of their disapproval of the defendant's discrimination by communicating to him in substance that she thought the treatment of the victim was wrong. While plaintiff did not say in so many words that the Ibiza incident was discriminatory, he made clear to Ms. Pete that the conduct was unlawful and wrong. At the pleading stage, the court finds that this allegation is sufficient to constitute a plausible protected activity. Likewise, plaintiff's allegation regarding his opposition to the alleged improper pay adequately puts his employer on notice that he is asserting statutory rights. Plaintiff alleges not that he told Megan his pay was too low. Let me see. Rather, he alleges that he told Megan he was not being paid all of the wages owed to him, which implies that an assertion of statutory rights. Additionally, he alleges that he challenged her purported unlawful wage practices. The court therefore finds that the plaintiff has adequately pleaded that he engaged in protected activity in opposing the violations under the law. The causal connection to the retaliatory conduct. Plaintiff has alleged facts sufficient to infer a retaliatory motive for the adverse employment actions at the pleading stage. Plaintiff alleges that that after he complained to Miss Pete about the allegedly harassing incident in Ibiza, and after she threatened plaintiff to never speak about it, he was booked less frequently than prior to the incident. And only 2 months after complaining about the Ibiza incident, defendant changed his compensation structure such that he would earn less for the same amount of work. These facts raise reasonable inference that the material terms and conditions of plaintiff's employment were altered in retaliation for speaking up about the Ibiza incident. Basically, you don't want to come to the party with us, then we're not going to book you as much. It's essentially what happened here. Okay. So let's keep going. Where we at? Plaintiff's allegation that he was fired within weeks of complaining to Megan about the alleged wage violations is sufficient to infer a causal relationship for the purpose of the New York law. Let's just do, and that's it. They just kind of end their sentences like, here, I'm going to quote a case, and that's it. I'm going to quote a case, and I'm done, okay? Extraterritorial application of the New York retaliation provision. Defendants cannot at this stage defeat the New York retaliation claim by arguing that the conduct occurred outside of New York State's geographical boundaries, because all that's required is that he worked in New York before, and then he can make the claim. So they got to wait until they get a little bit further into the lawsuit to say that he was not a New York resident and it didn't happen in New York. Okay, so plaintiff plausibly pleads that the defendant's retaliatory conduct occurred in California, sufficient to state a claim under the California Labor Code. Because plaintiff alleges that the decision to terminate him was made in California, the court declines to dismiss the retaliation claim under the California Labor Code. So essentially, since they told him that he was being fired while he was physically present in California, they basically was like, yep, that's good enough. That's good enough. So he can say that he was improperly fired there. And then we get into the aiding and abetting. Essentially, I'm just going to kind of summarize it because it's long and my voice is running out. It's running out, y'all. So basically, they said that he didn't succeed on accusing the employers of aiding and like Roc Nation and the other production companies of aiding and abetting, but he successfully concluded or alleged that Megan Thee Stallion was aiding and abetting and making like the production company fire him in retaliation of him speaking up in these incidences. So she knew of the harassment and the discrimination, and then she went to Roc Nation and was like, hey, we need to get rid of him. We need to fire him, get him out of here, okay? And so that was that one. And then we get to the end. I didn't know we was that close to the end, but we're getting to the end here. I knew we were close to the end, but not this close, okay? So let's keep going. So the leave to amend. Defendants' motion to dismiss are granted in part with leave to amend as described below. The court should freely give leave when justice requires. However, leave may be denied for a good reason, including futility, bad faith, undue delay, and undue prejudice to the opposing party. Plaintiff fails to adequately allege facts sufficient to plausibly plead FIHA claims, overtime and notice claims under California Labor Code, overtime claims under New York Labor Code, and aiding and abetting claims under New York human rights law. The court cannot conclude that further amendment would not cure those deficiencies in the amended complaint. The court therefore grants plaintiff leave to file a second amended complaint within 30 days of the order. And so essentially, there's still more. Conclusion. For the foregoing reasons, defendant motion to dismiss was granted in part and denied in part. The following of plaintiff's claims are dismissed without prejudice with leave to amend the described above. The claims 3 and 6 for the aiding and abetting, the wage and an overtime, the FIHA claim, the California Labor Code claim, and the California wage statement claim. Plaintiff's 13 claim for misclassification under California Labor Code is dismissed with prejudice, so he can't bring that one back. The motions to dismiss are denied with respect to plaintiff's remaining claims. So he will have the opportunity to fix the allegations. I can agree with the court that a lot of the statements were pretty vague. And we are going to need a little bit more information because, like, what weeks did you work in California that was over 50 hours? Like, you're going to have to give us some specifics. The July 4th week or Christmas break or whatever it is, okay? He's going to have to give a little bit more information. So I think he can come back on it. Like I said, I think they're trying to get rid of all the California laws so they don't have to deal with him because now they are in New York. But if it is true that he didn't plead sufficient facts, it's actually good that he got kicked out of California and over to New York to handle this. So let's go ahead and jump into the chat and see what the chat has to say. I know I've been kind of going for a while, so sorry for not saying hey to everyone as you guys were coming in. And let's talk about it. Well, do you think this was, reasonable for it to dismiss some of the claims? Do you think Megan should not be held liable for this? Now, I do think it's going to be a stretch for him to be able to prove the sexual harassment because there were other people in the car that were of different genders. So I don't think you can really make the argument. Like, his only claim is that if it was a heterosexual man, then she wouldn't have done it. But if it's a heterosexual girl, like, is that also an argument? If there was a heterosexual girl that was in the car and she was like, what are you doing as well? She might just be into that kind of stuff. So I think it might be a stretch to get to the sexual harassment. I think that there will be some type of settlement with the labor codes and the underpayment. They're going to give them some type of money. I don't think that she's just going to walk away scot-free with it. So let's see what the BriHive has to say. Layla Wells saying hi, hello, and welcome in. We got Lola Waterton, welcome in, saying hi. Joe W, hi, welcome in. I think you guys were here like before I even started. Kimmy Locker, member and moderator of the channel, saying hello, BriHive. Don't forget to like on your way in and make sure YouTube hasn't unsubscribed you. Yes, that is an important thing to talk about. Thank you, Kimmy, for the reminder on that and helping out with the live stream tonight. Mary Jane says, a further ado, I think. Oh, yeah, I was struggling with that earlier. Thank you. Mary Jane dropping the bees. Welcome in. Nice to have you back. Saying hi to Kimmy. Saying hi to Mary Jane. Saying exhausted. Y'all having a whole conversation. Let's see. Is Megan a guy? No, Megan is not a guy. Megan Thee Stallion is it's Megan Thee Stallion. It's a woman. And the plaintiff is a guy, Emilio Garcia, but he is a gay guy. And so he's basically saying he was discriminated against for being a gay guy. I don't know. I'm confused. Kimmy saying Pete is Megan Thee Stallion's last name. Yes. Okay. Yeah. Thank you for clarifying that. Says, oh, that sounded like it's a guy. Yeah, no, it's just her last name. That's kind of funny. I didn't realize that the plaintiff is a guy. Yes. Mary Jane says, did I get stung by a bee? No, I didn't. No, I didn't get stung by a bee. I thought maybe, yeah, something bit me, but no, I was golfing at Top Golf. Not golfing, but I was at Top Golf. Hi to Tanya, or Destined to Be, moderator of the channel. Hello, welcome back. Let's see, and saying I see you because I was having that technical difficulty. Saying hi to Destined to Be. Saying I almost fell asleep. It's all good. Destined to Be saying, I'm just here for the view time. I just got to Vegas and functioning on zero sleep. I'm going to bed soon. Well, I hope you have a great, wonderful time in Vegas. I was supposed to go last weekend and I didn't go because of the windstorm. So I hope you have a safe trip and I hope it is lovely and fun. Are you going to see a concert? I know you like to go there to see concerts. Kimmy Lockett says, oh, sleep tight and have fun. Yes, of course. Hi, Autumn. Welcome in. Nice to have you back. Thanking Kimmy. Let's see where we at. Kimmy says, I wonder what, if any, receipts he has. Yeah, probably none. Because this kind of seemed like, oh, you're my friend. Oh, you film good videos. Hey, if you come and travel with me, I'll give you $4,000. It doesn't really sound like a legitimate employee relationship. Kind of sounds like more of a friends thing. And I doubt he kept track of it. But what happens a lot in these kind of cases, as we know, is they'll just settle. They'll be like, okay, fine, here's $50,000 or whatever, go away. And I think that's more what he's hoping for. I don't think he's gonna have the proof to be able to prove the case. Autumn saying that I'm getting ready for bed. I know I'm streaming late on a Friday, so I appreciate all y'all for still stopping by. It sounds like most of BriHive is. I know, because it's like what? If you go to the East Coast, 11:30, almost 12. We are doing good. We're happy to have you back. Let's see. Can we say I'm tired but good? How are you? Pretty good. Yeah, so that was Megan Thee Stallion's sexual harassment lawsuit that doesn't really have a lot of sexual harassment in it. I think the goal is to get a little bit of money for what he believes that he wasn't paid in working for Megan Thee Stallion. And would it have been more than $4,000 if he was even being paid minimum wage and overtime? I don't know. The meal and rest breaks, he will probably be entitled to some extra money. I think this thing settles for 50 to 100,000. I don't think we can get really beyond that. I don't think he has a claim for the sexual harassment because there were so many other people in the car. They said that she started to engage in the activity with one person and there were three, I guess one other lady in there. So I don't know if he's going to be, I don't think he's going to be able to succeed on his claim. I don't think this goes to trial. I think it settles. I think she gives him a couple $1,000s and I'm thinking somewhere around the $50 to $100,000 range, but I don't even know if we get there. We might be looking at 25,000 because if we're even just talking about paying him minimum wage, that's only almost $3,000 a month. So if he got an extra 1,000 out of that, that might have accounted for the overtime that he might have been due. I don't know. Let's see. Okay, you guys are having a conversation, so I'm not going to pull up those chats. But thank you for everybody that voted on the poll. That's how we ended up covering this case. As a lot of you know, I am in a new job. I've been there for 3 months now. So, shout out to me, almost on the 4-month mark. And so I'm still trying to work out how I'm going to move forward with the channel and what kind of stuff that I want to cover on here. I feel like I have a hard time coming up with ideas lately. So I'm just trying to get a schedule on how to get the channel where I really want it to be. And I appreciate everyone that comes and supports me on a weekly basis. I'm sorry that I've been streaming on different days, and I definitely appreciate all of you guys for being accommodating. I hope everyone has a wonderful weekend. I will let y'all know when we'll be streaming next, and I will see y'all all on the next live stream. Bye.